Welcome into the attorneys. Appreciate you spending your Sunday evening with us. An interesting show tonight. And as we head into the show tonight, a reminder right at the forefront that we'd love to hear from you. Several ways for you to get in contact with us for the next half hour. You can do so several ways. You can call, you can text, or you can email, and that information will be on the screen throughout the program. The whole purpose of this show is to answer your questions and get those questions to our panel of experts, led tonight by our friend from the firm of Hollis, Wright, and Couch, Steve Couch. Good to see you, sir.
Good to see you. It's nice to be here again.
Well, I'm glad you're back, and our topic of conversation tonight, something else that seemed to affect a whole lot of folks.
You're so right, you know, and because of the headlines and the news that's come out lately, compounding companies and other pharmaceutical companies recalling drugs, we thought we'd do a show about bad drugs and what people can do, if they can do anything, when they get hit with that. I mean, when you look at the statistics today and the number of people who take pharmaceutical medications, and it's a lot of them. In fact, I think over 60, when you're over 60, most people, I think it's in the 90%,
right.
They're taking at least one medication, one prescription medication. So we thought we'd get some information out there to tell people what to be mindful of when they see these recalls and when they're having adverse effects, etc. Tonight, because of this topic, our firm does this. We've brought on Bobby Bell, who's a lawyer with us, has been for years, and he handles a lot of our pharmaceutical litigation. Bobby, thanks for being here.
Thank you.
Bobby, appreciate the time. Let's kind of, from a jumping off point, talking about this subject, I can't think, but, whenever you see a commercial for a drug,
sure.
It seems as much time is given to kind of the disclaimers as to talking about the product. What are the requirements and the responsibilities of the pharmaceutical companies in terms of letting us know
Sure.
of possible side effects or dangers associated with the drug?
The drug companies, from the moment it hits the market, they have to adequately warn about any risk or adverse events.
Right.
And it doesn't stop as soon as it comes on the market. Through the life of the drug, if they start hearing things, or just once it hits the general population, is usually where you start getting a lot of these adverse reactions they didn't even think about or see in the clinical trials. They have to, notify doctors, notify the FDA, keep their label up to date, because it's very important. If you're taking something in your body, you need to know exactly what the potential risks are.
Right. Yeah. And is that why? I mean, so much, do they have to, I guess they don't have to give every side effect, or do they? Because those ads, once you know what I'm talking about, whenever you see them, you're watching a game,
sure,
and they have an ad, and as much of the ad is talking about all these side effects, it makes you wonder, why in the world would I ever want that if that's a potential side effect?
Well, they actually, they have to warn about anything that they know it can be a risk or a side effect. In the ads themselves, I mean, I do believe they have the right to probably chop it off a little bit. If you ever opened up a drug packet and read it, I mean, your commercials would be, as long as the show.
Yeah, right.
So I think they do have to do at least, the main risk and the main adverse effects that can occur, but they don't have to say everything in the commercial. It just would be impossible.
Yeah.
But as far as the label goes, yes. I mean, everything that they know that this drug can cause, or any adverse effects, that is their duty to do so.
I think the FDA also discourages companies, correct me if I'm wrong, Bobby, but they discourage from overwarning, doing the laundry list of, here's every adverse event that we know could possibly happen from any medication, just cutting and pasting onto a packet insert. I think they discourage
They do. It would be defensive labeling, basically, and the company most likely wouldn't really want to do that anyways. I mean, this is a competitive market. The moment you start putting 50 things on there, and your competitor only has maybe 5 or 10, you're probably going to lose some business. But they're not supposed to do that. It actually has to be based on something. They can't cover themselves just by listing everything that possibly could happen, just in case it happened, and then they can say, well, we warned it. It doesn't work that way.
Yeah, and a lot of the litigation in this area, not every drug, but certain drugs, has arisen out of what companies have been made aware of in terms of adverse events, say it causes death or birth defects, etc. They'll get this information, and then they don't turn around and report it to doctors or patients, etc., because they're saying, well, this was a little bit different, or there wasn't enough events to justify us warning for this particular things, or they just lose the study. We've seen that happen before too.
Well, what sort of recourse does a viewer have, or someone who begins taking a drug, if it has side effects and has an effect on them? that there is no warning for? What sort of what sort of recourse does that patient have?
Well, mainly it'd be a lawsuit. I mean, that's the only way you're usually going to get these companies to pay. They usually don't come to your door and say, "We're sorry, here you go." And the basics on the situation you're mentioning, where they don't put a warning, it's a failure to warn claim.
Right.
And even just jumping ahead a little bit, even if they warned a little bit, the warning still has to be adequate. So let's say they said there's only 1% chance, when truly the evidence showed there's 20% chance. That still can be a failure to warn. It's just they warned, but it wasn't adequate. And that's the type of claim you bring. You're going forward, you file your lawsuit, and you're saying, you have a duty. There is no doubt. They have a duty to warn about these things that they know can occur, or they should have known that can occur. And in a situation where they didn't warn, it'd be the failure to warn suit, and you're basically showing that the company knew, they did not warn, and I was hurt as a result of this, what they did not warn about. You can say it another way, that if the warning would have been stronger, my doctor would never have given it to me, and I would never have this injury. And that's what your claim is.
Right.
Yeah, and Bobby's exactly right. And depending on the symptom that somebody might be experiencing, say they take a medication. I'm going to talk a little bit outside the context of a lawsuit here for a second. But say the symptom is nausea, vomiting, dizzy, or whatever. I mean, that's not necessarily the type of claim that you would file in a court of law. Rather, I think the person should call or get in touch with, even email, if there's a website for FDA or the drug company, and say, hey, by the way, I had this symptom happen to me. I didn't see it on the label, or I just experienced it. I just experienced that symptom. The FDA will then forward that information on to the company so that they can, and where they should, keep up with the adverse reactions that people were having. So if enough people are actually reporting it to somebody, then that information gets back to the drug companies. When you get enough of that, then that's when they turn around and they have to warn folks.
How good is the testing, and how trustworthy, let's use that word, how trustworthy is the testing? And the reason I ask this is because I just wonder if there are drugs that make their way to the marketplace that have side effects that they're never warned about, and they don't even know that until it's already, there are thousands of folks using this, and then come to find out, there's a side effect that nobody was ever warned about. I mean, does that ever slip through the cracks like that?
It does. I mean, and that's a lot of cases we've handled. That's usually what happens. You got to understand, when they first start to make a drug, they'll do these clinical trials. I mean, this is in a setting, a doctor setting. You don't always know, and I'll give them credit for this, you don't always know how it's going to affect the general public. But we're talking about, as soon as it hits that general public, and Steve mentioned this, you start getting these adverse reports phoned in or called in. You can do it on the FDA's website. You can say, I took this drug, and here's the adverse I had that wasn't warned about. Once the companies start seeing these things and hearing about it, and they do nothing, they don't warn doctors, they don't change their label, then you have a right to pursue. But unfortunately, it does happen. I mean, we're seeing it in a number of cases. A certain case we're working on now would be Actos. It was a diabetic drug, and the claim right now is that long-term use can lead to bladder cancer. And it was never mentioned, although the theory is, or the belief is, that they should have known this, that it was appearing in their clinical trials. There were enough results, adverse results being issued, that it should have caught on, and they finally have changed the warning to include that. But in our opinion, it was a little too late for many of our clients.
Yeah, and in addition to that, I mean, there's something called off-label uses, and I want to talk more about that later on the other side of the break. But to answer your question, yeah, there have been several instances in recent history where drugs make it to the market, people are suffering adverse effects that, candidly, drug companies do know about them, but they never warn about them, because then they wouldn't sell as many drugs. At least that's what the evidence showed in those cases. All
right, time for our first break. As we head to break, a reminder, call, text, email. Would love to hear from you. You can also find the firm of Hollis, Wright & Couch. If you just search that term, Hollis, Wright & Couch, you'll find them on Facebook, also on Twitter. That's Hollis_Wright. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free. So if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Welcome back into The Attorneys, talking about pharmaceutical companies and their responsibilities with what they what doctors prescribe and their products. As we begin the second segment of the show, I want to remind you that throughout this program, we would love to hear from you. We don't just say that. We love hearing and getting your feedback, your questions for our panel of experts. You can call, text, or email that information on the screen throughout the program. Joined by Steve Couch and Bobby Bell, both at the firm Hollis, Wright, and Couch. And Bobby, earlier you were talking, you used the term a failure to warn lawsuit. What do you have to prove in a failure to warn lawsuit?
Basically, first you got to start with the drug has to cause an injury. And that injury that was caused was not warned adequately by the drug company. They should have known or had reasonable, they either knew or had a reasonable understanding that they should have known that they should have warned about it. And that the failure to warn is what resulted in your injury. And I said this, and I kind of will say it again, to put it in other words, you would have never taken this drug if there's been a stronger warning. You would have at least understood the risk, and you would have had the right to make that decision whether you're going to take it or not. But because you didn't understand it, you took it, and now you're injured, you have the right to bring a claim.
Yeah, and you know, the realities of the marketplace now is that generally when you go get a prescription filled, they'll say, do you want generic? And a lot of people say, yeah, because it costs less.
Right.
Yeah, it makes sense. Bobby, kind of talk to us a little bit about the differences of a generic drug versus a labeled drug in the context of the law you just talked about.
Okay, this is big. Last year, the Supreme Court made a decision in a case called Pleva v. Menzing, and just to understand a little bit about the case, it was a drug called Reglan. That's the brand name, and it's for heartburn, stomach issues. I'm trying to make it too short so not go too long in it, but it is only supposed to be taken for a short period of time. However, the company knew that people were taking it for longer, 12 weeks or more, and sometimes years. And it had the potential to create this neurological disorder called tardive dyskinesia. And they never really warned about it. So a lot of suits were filed. Well, the problem was that Reglan was now generic. Metoclopramide is the generic name. And some people who were injured, developed tardive dyskinesia, tried to bring a suit against the generic manufacturers. And it went through the courts, got to the Supreme Court, and the Supreme Court came down and said, you cannot bring a failure to warn claim against a generic. The basis of that is that there are certain FDA regulations that say a generic has to follow the brand name's label.
Right.
It cannot change. It cannot go out on its own. It can't warn doctors. It can't do anything. It has to stick with the brand name. And that was the defense for metoclopramide, saying, well, sure, we understand this probably caused this, but we couldn't change our label. And the Supreme Court agreed with it. And it's a scary opinion in my decision, my opinion, that even in the opinion itself, towards the end, Justice Thomas even says, if these people would have gotten the brand name, they have a case. But because the pharmacist gave them a generic, that's it. There's no way to bring this failure to warn claim. And it's not only failure to warn, so many things are based off that you really don't have an action against generic manufacturers. And the reason that's scary is my understanding is about 75% of the drugs taken now are generic.
Right.
And it really takes away the consumer's rights.
Yeah, and this opinion by the United States Supreme Court that was handed down last year, I get excited when we talk about this, excited not in a good way.
Right.
Because ultimately the effect of the opinion is to give immunity under the law to generic drug manufacturers. The U.S. Supreme Court also said a state can't have a more stricter warning law than the FDA. And to me, that's, I have a hard time accepting that. I have to accept it because now that's the law, but I do have some problems with it. I mean, this allows, this case allows generic drug manufacturers immunity, even if they knew that a particular drug, generic version that they're making, does cause additional problems and even death in some folks. They don't have to warn about it. In fact, the U.S. Supreme Court has told them they can't worry about it. You know, and one of the reasons I get excited is because I see these opinions handed down year after year after year, and the effect, big picture that I see is just a slow erosion of people's rights to do anything about it. And I get upset when I hear it because it keeps happening a little bit by little bit by little bit at both at the federal level and at the state level. You know, look, if this happens long enough, David, folks are going to get what they asked for, which is the right to sit down, shut up, and do nothing about it when either them or their family members have been harmed, and I get upset about that. That's why I always encourage people, look, get up and vote. Get out and do something. Don't just let people shove stuff down your throat. Get up and vote. I don't care which way you vote. You can vote based on how somebody looks, a party, whatever. Just get out and do something. Don't be apathetic. And I've said that many times on this show.
Yeah, yeah. Get on your soapbox.
I know, I'm sorry.
Yes, that's right. Does it matter if there's no brand name manufacturer left to change the label?
It doesn't, and again, that's why this decision was so damaging. Even if there's not a brand name, you still cannot go after the generic. The generic has no authority per this decision to change the label. They, you know, obviously you would assume they probably didn't want to, but they get to sit back and say, we can't. I'm sorry. Never mind, they are allowed to keep selling the drug. Never occurs, I guess, to stop selling the drug.
Right.
But they get to sit back and say, we can't do anything. And there's nothing to base on. Even if there is no brand name, there's no one to go after.
Yeah, and the manufacturers are allowing, because of the opinion, I think, they're allowing their patents on that brand name to expire, so that now they can turn into a generic drug manufacturer themselves and have this immunity that Bobby was talking about earlier. And it's a reaction to the opinion from last year, I have no doubt.
So if that's the reality from a consumer standpoint, what options do we have? What can we do?
Well, there's two things, probably maybe some more, but the problem is when you go to your pharmacist, you can ask for the brand name. Everyone knows what the downside of that is. It's going to be twice as expensive. It's probably unlikely you're going to do that. You know, sometimes the pharmacist might even switch to generic without even asking. The other thing you can do, and it's really the only thing you can do, this decision will only be changed by an act of Congress. You need to talk to your legislatures, your congressmen, because it needs to change. There should be protection for people when you're talking about 75% of the drugs in the market are now immune from having to change their warnings. Even if they're aware of it, they don't have to do anything. That's just something not right about that. So either go expensive, you know, and just tell yourself that I'm paying a little bit more because if something does happen, I do have the right, because brand names, you still can go after. That Supreme Court decision had no effect on that.
Okay.
Or on the other hand, which is probably more realistic, get out there and, as Steve said, vote, talk to your congressman. That is the only way that law is going to change.
Yeah, if folks think that this opinion is innocuous and it's just out there, something that happened last year that affects other people, they're wrong, because eventually all of us, if we're lucky to live long enough, probably going to be taking some form of medication before we get in the ground. And basically you don't have the right to do anything. To answer your question, what can they do? Well, you either spend more on medication or you do nothing, unless you call your legislature. And look, you don't have to pick up the phone anymore. They have websites, you can tweet them, Facebook them, whatever. It takes just a few minutes and say, hey, I want the law changed with respect to generic drugs.
Right.
Something like that. Just do something.
All right, time for our final break of the evening. A reminder as we do so, still time for you to get in touch with us. Call, text, email. Also find the firm. Just search Hollis, Wright, and Couch on Facebook, Hollis_Wright to find them on Twitter. The final segment of the attorneys coming right up.
I'm Josh Firth with the law firm of Hollis, Wright, and Couch. When it comes to a lawsuit against medical professionals, it may seem like the law favors the medical community over the injured patient, and in many ways it does. While not every bad medical outcome is malpractice, it's important to know what obstacles you may face if you're injured as a result of poor medical care. So in tonight's Legal 411, we're answering the question, does medical malpractice really exist? The answer is yes. But if something is ruled malpractice, Alabama law limits the information that can be presented to a jury about a medical professional. Medical malpractice is defined as a doctor's failure to use the degree of care and skill that a physician or surgeon in the same medical specialty would use under similar circumstances. For example, a surgeon can only be judged by the standards for a surgeon, a dermatologist by the standards for a dermatologist. According to Alabama law, we have what's called the Alabama Medical Liability Act. This prevents juries from hearing about a doctor's past mistakes or malpractice that's occurred before, limits the scope of information available to the injured party, and prevents any mention of liability insurance, which would pay a judgment, the very point of malpractice insurance in the first place. However, even with these restrictions, malpractice cases can still be won. The law protects both parties and provides access to the jury system for people who have been injured after poor medical treatment. That's why it's so critical to get legal help quickly if you face this situation. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on Alabama's 13.
Time moves quick on our get-togethers every Sunday night. The final segment here of The Attorneys, but a reminder, ways that you can get in touch with us on the screen. Love to hear from you. Call, text, email here, talking about pharmaceuticals and the drugs, prescriptions, what doctors prescribe, and the warnings. Steve Couch, a good conversation tonight.
Yeah, it is. And, you know, before the break, I don't want to sound like gloom and doom and Johnny Raincloud. There's nothing that people can do in the event that they're injured. There are other theories other than a failure to warn claim that people may have, depending on the drug, depending on what happened. I'm going to let Bobby kind of talk about the alternative theories, at least that people have under the law.
Okay.
That may be potential avenues.
Yeah, and going back to brand name drugs, you still have your failure to warn. Other issues you have are your breach of warranties, just like in any product. You bought it, it was supposed to have a specific purpose, and it failed to live up to that purpose. Manufacturing defect is one that is still out there, and you will probably see this more. We actually had something scare not too long ago in Alabama about these TPN, these IV bags were contaminated at the compounding factory. And that would be a manufacturing defect, where it's not so much it was a failure to warn, because it never even got to that point really. It was, you know, either poor design of the drug, but poor conditions in this case, allowing some type of contaminants to get into the drugs. You know, another issue that's happening right now, you're hearing everywhere, is this meningitis outbreak. Right. And that would be, again, my understanding is related to a compounding company where you would be looking at a design defect or a manufacturer defect.
Right. Yeah, Bobby's exactly right. What you're seeing more and more these days with pharmaceutical companies is the farming out, if you will, of the actual mixing of the drug and making it. And the reason it saves money. And like Bobby mentioned, there was the TPN bag scare. They were down in Shelby County, and basically a contaminant got into feeding bags. People used the liquid food, what they were fed with, and they got sick, and some died. Also recently, like Bobby said, there was that I think it was the New England Compounding Company up north in Massachusetts. They recalled, I think they gave a 71-page list of over 1,200 medications that they had made. Right. They recalled them nationwide. I think there were 70-something folks that got sick and some deaths because of a lack of sanitation. It was fungal meningitis is what those drugs were contaminated with, and we've heard a lot about that. Interestingly, I looked before I came on tonight, and there are zero federal standards with respect to sanitation at compounding companies that make drugs that people ingest in their bodies. I think there should be a push for that, if there's not one already started, to hopefully set them at a standard for sanitation, cleanliness, etc. Because these medications go out nationwide, worldwide, and people ingest them into the body. It could kill you. Yeah. What I have found is that most states, like Alabama, just throw it all to the Department of Health. And the Department of Health, as I've learned, they do a couple of inspections. They do an inspection when a compounding company opens for business, when everything's new and shiny, no different than up north, and if there's any complaints. Those are the only 2 times the health department does an inspection at a compounding company, which I think that's kind of sad, actually.
Right. It's hard to believe that we're almost out of time here. But before we wrap up, we've got about a little more than a minute left. Sure. But from both of you guys, maybe something, a final thought or something that you want to be sure that's passed along to the viewers.
Well, I want people to be aware that they can do something, albeit, with the decisions that are being handed down, they're limited in what they can do. But if you suffer an adverse reaction to a medication, go seek medical attention first and foremost, of course, but contact a lawyer, whoever it is, if you think there might be a claim there, because some of these medications can absolutely kill you.
Right. Bobby, how about you?
And I would agree with that. Certainly make the companies aware of these adverse reactions. A lot of times doctors don't get around to doing it. They need to do it because that helps us track what issues need to be adjusted. And again, talk to your congressman, senator. This generic thing needs to change. There's just too many generics out there.
Yeah, Steve and Bobby, appreciate the time tonight.
Good to be here.
Thanks so much for being with us, and thank you as well. We appreciate you tuning in as we wrap things up. Reminders of ways you can call, text, and email. Those will make their way to the firm of Hollis, Wright, and Couch. Find them on Facebook. Search Hollis, Wright, and Couch, or on Twitter. That's Hollis_Wright. Thanks so much for being with us, and we'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.